You're listening to podcasts from the Congressional Internet Caucus Academy.
Thank you, Matt. I'm David McCabe. I'm a technology reporter for Axios, and I cover sort of the collision of policy with technology, and we're really excited to be here. Just quick introductions. Going this way, we have Ariel Fox Johnson of Common Sense Media. Then we have Ryan Hageman of the Niskanen Center, which I'm always worried about mispronouncing, but I think I got all of the N's. Then we have Michelle DeMoy of the Center for Democracy and Technology, and then Jordan Crenshaw with the U.S. Chamber's Chamber Technology Engagement Center. And I'm just going to quickly set the stage a little bit. We're talking about the new consumer privacy law that just passed in California. For those of you who don't know, this was a law that came into effect, or came to be sort of as a result of a potential ballot measure. There was a chance that California voters would vote on a consumer privacy measure in November, and essentially the sponsors, the supporters of that ballot measure said, we'll pull it from the ballot, or we won't get it on the ballot if you pass this bill by the filing deadline for the ballot. And so that came to pass earlier this year. It was a pretty quick process, at least externally. It all seemed to come together very quickly. But the law doesn't go into effect for several years. It goes into effect in 2020, which means it could be altered in upcoming legislative sessions, and I think many, in fact, think that it will. Obviously, the big picture here is that increasingly you have people around the world and around the country articulating ideas about how consumer privacy should be regulated as these big platforms, these big web platforms come under pressure. So, of course, the biggest example of that is GDPR in Europe, which just went into effect and had been sort of cooking for several years rather than the much shorter period of time in California. So you have this increasingly sort of splintered environment in terms of consumer data privacy, and what we're going to talk about today is sort of what these different measures do and what they are, what they might mean, who they apply to, and then we'll talk about what it means for Congress, and then we'll take questions. So I think starting out, Ariel, obviously Common Sense Media was super involved in the crafting of this California bill. Give us sort of the high-level 101, what it does for consumers. What rights does it give consumers over their data?
Sure, and Common Sense is one of the co-sponsors of this legislation, and we're excited that it's a great first step, and it's the first sort of broadly applicable. Thank you. Yeah. First broadly applicable consumer privacy law in this country that's not just sectoral, not just financial, not just health, recognizes that personal information of all sorts should be protected, whether it's from kids or teens or adults. So a couple important rights that the California Consumer Privacy Act gives. It gives people the right to know what information is collected about them, including generally what sources it comes from, what the purpose of collection is, if the information is sold, what the purpose of the sale is, and also the sort of categories of third parties who the information might be sold or disclosed to. It gives people the right to access their information and to port it to a competing or another service if they want. It gives people the right to say no to the sale of their information, and especially exciting for Common Sense because we're really focused on kids and families. If you're under 16, you have to say yes, or under 13, your parents have to say yes before your information will be sold. So it's an affirmative opt-in right for under 16-year-olds. It gives people the right to request that their information be deleted. And it also provides protections against discrimination for people who are trying to exercise their privacy rights.
So, Michelle, how does this compare to the GDPR? And yeah, if our panelists could remember to turn on the mics.
How does this compare to the GDPR? Well, I've heard, first of all, thanks for having me. Hi, everybody. I hope you enjoy your sandwiches. A lot of what I've heard, there's sort of a rhetoric that's surrounded the California bill that said it's the GDPR of California. And I think that's wrong. I just want to state that, and you may have heard it too here, it reflects and echoes some of the individual rights that are in the GDPR, including access, deletion, and portability, but the way it spells them out is very different. The GDPR has more meaningful fines. It's across a much larger base in terms of the EU. It also makes a distinction between data controllers and data processors, which is sort of a foundation that is not in the California law, but for reasons that I understand, it's sort of California law already has the right to privacy enshrined, and there are provisions around that, so it wouldn't have made sense probably. But it also has provisions like doing an audit, doing a data risk assessment, things that are a little more granular and detailed, and I guess if you're a company, more of a headache than what exists in the California law. There's some interesting parallels, though. I would say the California law, for example, the age thing, 16. In GDPR, that actually varies by member state. So if you're a company, that's another giant headache to try to comply with different member state varying provisions as they relate to the GDPR. So you can be sued also in different member states for different provisions. Whereas the California law is much more broadly applicable, clearly, unless you count California in 3 states, which I guess is off the ballot now. The other parts that are not like the GDPR, which I think is the opposite of what you asked, but is the definition of personal information is really broad. I think probably the authors were trying to capture the data ecosystem as it exists right now, which is incredibly difficult to capture in the idea of personal information. So it includes things like olfactory data, which is smell data, nose data. It also talks about household data, which is really difficult to define. It sounds easy, but it's really not, if you think about what that actually means, as opposed to personal information and how those two things go together. The access and deletion rights are weakened in the California bill. So the access rights are in the California bill talk about you can get categories of information, and it's about sort of the entities that have some data on you. So if you're a consumer and you think about what you want to access to eventually port probably, or at least give yourself that possibility, it's really tricky to know what you can do with categories of information versus sort of everything they have on you, which is also not technically feasible for a company to do, nor really what you probably want. So the bill is trying to strike a balance there. The other part is the deletion is significantly weakened also. It's not a deletion right, it's a right to request deletion and hope the company does it. And so, unfortunately, that provision, while I think it's trying to give companies flexibility when it comes to deletion, this is an incredibly difficult technical thing to do. Our data is splintered into 1,000 pieces when companies get it. It's monetized in different ways. It's stored in different ways. And it's also not clear necessarily what your data is versus your data and someone else's. Think about an email. If I send you an email, is that yours or mine? Right, so that's a really simplistic way of thinking about how really complex this can get. But that said, this is not an affirmative right for somebody to delete. You can request it, and the company has lots of ways of denying it, and including just sort of operational uses type provisions.
And we'll get in a little bit more.
Sorry.
I think no. It's all really interesting stuff. I think we'll get in a little bit more to the places where the bill might be changed, or where where there might be more opportunities for stricter or less strict enforcement. I do want to quickly, before we to Jordan and Ryan, Ariel, walk us through a little bit why it's important, or why Common Sense felt it was important to include measures specifically directed and opt-in measures, which are sort of the most significant privacy guardrails for teenagers.
Yeah, well, I mean, Common Sense, and I think a lot of consumer advocates would love to see opt-in for everything and for everyone. That was not sort of feasible in this environment, and so we have opt-in for the most vulnerable, most tracked generation, which is our kids, and also teenagers. And the teenage piece is really important because while we have COPPA, which is a federal law that protects privacy of kids under 13 and their personal information, before this, we had nothing protecting young teenagers, and from our perspective, like being a 13 or 14-year-old doesn't really make you that much more savvy about how companies might be using or selling your information, or how you might be tracked and targeted across the web than when you were 12 and a half. So that's why it was really important for us to have opt-in for this. And also, we know that defaults are important, which is one reason opt-in for everyone would be great. But defaults being really important and it being hard for people to change defaults, we want the default for kids and young teens to be, you don't sell your information.
Yeah. Now, Ryan, you have called this bill a business destroyer. Why?
So.
Well, I don't know if I use those exact terms. I kind of get this bill and GDPR mixed up in my head a little bit, but I do believe the phrase "innovation death knell" has been used on multiple occasions.
That seems like a one half dozen of the other six of the other. Yeah.
Right. I mean, so I guess, and we can drill down into this more in detail as we go on and as interest demands, but sort of my broad-based concerns here with regards to bills like what California just passed and rules and regulations like what were recently implemented in Europe is basically two just very broad general buckets. The first is that trade-offs between unseen and potentially unintended consequences really aren't given a great amount of weight and consideration in these bills. So for example, in the California bill, the broad definition of personal information, the actually somewhat broad definition of business itself essentially scoops up potentially everything, right? So one of the big problems here is that vague definitions that are included in these sorts of rules aren't really being cognizant and I won't say respectful, because I do think that people are aware of the fact that the digital economy is a not insignificant part of our daily lives, and that it not only drives, new innovations and, new startups and businesses, but it also drives job growth. It drives well-being for individuals and their families who are employed at firms who may or may not be, who may be directly or indirectly tied into this broader digital ecosystem, right? But my concern with sort of like these broad, vague inclusions in bills that try to just sort of cast a wide net and just try to rope in all potential harms without narrowing down into particularized, contextualized harms that people are actually experiencing is that all of the unseen consequences of that basically don't get any sort of limelight or showtime, right? So the jobs lost, the potential innovations that are lost, which technically we'll never know about, right? After GDPR was actually implemented, and in fact in the weeks leading up to its effective date of implementation, a number of startups in Europe just shuttered their doors. And just to sort of give you the context of how dire that actually is for the European technology industry, of the top 25 global technology firms, global, in the world, 15 of them are in the United States. 3 of them are in Europe. The difference between the total market capitalization of those sectors is US approaching $5 trillion, depending on what happens with Amazon or who's the first to reach $1 trillion. The entirety of the top 3 European tech firms amounts to about $285 billion. Now, just to put that into a slightly more narrow context, that is almost the market capitalization value of just IBM. So my big problem here is that vague standards, not taking account of the other trade-offs that we really do need to consider when we're essentially applying very potentially onerous, burdensome, and confusing rules to a wide swath of the economy.
And Jordan, let's talk about who it applies to. How broadly does, GDPR, I think it's been reported, it applies fairly broadly. This has been sort of covered as it's rolled out. This California bill, let's say it doesn't change at all. In 2020, who's affected? Is it just the big companies? Is it small companies and big companies?
This is not just online. This is every business in the country let's put it this way, every business that does business in California that makes over $25 million in annual revenue. I think that pretty much covers any large company in the country, which effectively makes the California law a de facto privacy law for big businesses and big to mid-sized businesses across the country. Covers everyone from the airline industry to the brick and mortar retailers, the online retailers. It's not just the social media platforms of the world. And I think that's what's so concerning, I think, to us about what happened in California was that when you are bringing such a wide swath of industry into a privacy bill with, a bunch of terminology that has not been worked out through regular order and process, that's problematic when you're essentially creating a privacy regulation for the rest of the country. I wish that we could see bills move in 4 days on the floor here in D.C., but that just doesn't happen. But I think it's telling from the Senate Judiciary Committee hearing when this was passed that the chairwoman of the committee basically said that she had grave concerns about the legislation and the process, and having this ballot initiative essentially put a gun to the head of the California Assembly to get something done within 4 days before the deadline passed to remove the initiative from the ballot. Look, I think that there is a need for smart and good regulation, but I think what we've seen from what we saw in California was that we need to get things right, and we need to do things from a good process perspective.
It probably does, though, have to apply right across. It can't just be social media, right? Like, everybody uses data. I have an app for, like, the city bike share in New York because I used it once. Now they have some of my data, right? It's not.
It's pretty much every company, other than there were some carve-outs. There was a GLBA, Graham Leach Bliley, for the financial institutions. There was a carve-out for HIPAA as well, too, for the health industry folks as well. But for the most part, this is, I think everyone has focused this debate on the online world, and this actually now brings in everyone from the brick and mortars to the online social media platforms.
Which, we think at Common Sense it's a good thing that it's including all of these companies and not making a distinction, at least between like brick and mortar and online, because all of these companies are collecting your data, selling your data, and you might want to be able to tell an airline to stop selling your data, or you might want to tell Macy's to stop selling your data. So, and
this Massachusetts State AG just testified that most of the data breaches that they deal with are from small businesses, right? So we don't want to incentivize small businesses, which all of the big techs started that way, right? At least according to the mythology, as small startups. So we don't want to sort of incentivize bad practices for small and mid-sized businesses also.
I want to quickly, actually, though, talk about the big companies, because so I've read the sort of key portions of the bill when it went through. Are Facebook and Google already in compliance with this, or are there things that the bill would have them do for users that Facebook and Google don't already do?
Who wants to answer?
It's sort of
I'll take a stab at that. I think every company and the nation is still reviewing what this law means to them, and I don't think we quite know yet what implications this has for everyone. So I think it's premature to answer that question at this point right now.
I'll answer it. Sorry. I think the answer is no, they're not in compliance. I think that's part of why they hate it so much. It is, like I said, it's not, in fact, a GDPR for the U.S., where maybe they would have been more closely in compliance. But there are provisions, for example, putting some kind of link on your homepage for Californians that says, please do not sell my data. Now, does anybody in here not like that idea? So it reflects, this public dissatisfaction with the way that our data is unexpectedly used and shared. But the companies like Google and Facebook and others have a legitimate concern about, that property is hugely valuable. For example, think about the Google homepage, the search page. They're putting a button up there for California consumers is a pretty big deal. And I think for them also sort of makes an implication that they do things with data that they don't feel like they do. So there's still a lot of time for some of these things to be worked out, and no doubt they will explain more clearly to us how they are not in compliance currently.
And I will say, I think Facebook, I know Facebook said that they supported the bill, that it wasn't perfect, but that they supported the bill. I don't think Google made a similar statement, but just for context. And of course, trade groups that represent Facebook and Google were much more aggressively questioning and skeptical of the bill.
Well, remember the reason, though, right? That they were facing the ballot initiative.
Right.
So that sort of was a gun to the head of a lot of companies who really, really disliked that, and mostly because it had a private right of action, right? So you could sue them, and they're already being sued left, right, and center. So that was a really big liability that they didn't want to take on. And so there's sort of I don't know that they full-throatedly support the California bill, but they supported it in relation to the initiative.
I'll add one other difference, too, as to why I think a lot of industries viewed the bill as preferable to the ballot initiative, was that the initiative itself basically said that the California Assembly had to develop a supermajority of 70% to amend what was in the ballot initiative. So, I'm an attorney, but I hate to admit this. Whenever I get ballot initiatives that I look at, or the amendments in Virginia when I'm voting, I say, yeah, that sounds like a good idea most of the time. I just go, yes. So, I mean, I think at least from a perspective of passing this law, it did enable the California Assembly to kind of have more of a robust debate about this issue and give it some more flexibility to amend things that actually might be friendlier and provide more certainty to both consumers and to the business community.
And just briefly on the private right of action, right, because my understanding is it shifted a little bit as the bill got closer to the finish line. Ariel, can you just quickly walk everyone through how the private right of action works now?
Sure, I can do my best. So under the initiative, you had a private right of action for anything, for any violation of the initiative. Under the current law, you have a private right of action for security breaches, defined, I think, as like unauthorized access, exfiltration, theft, disclosure, and it's security breaches of specific pieces of personal information, so more narrowly defined than personal information is otherwise defined in the bill. Common sense would prefer that it was more broadly defined, but that's where you are. And under this private right of action, you can get $100 to $750 per violation. And you also have to tell the Attorney General you're bringing suit. And if the Attorney General wants to bring the suit instead, and they're the ones who enforce the rest of the law, then they can do so. So it is a significantly more limited private right of action than was in the initiative. On the flip side, you have more expanded consumer rights in the bill, like this new right of access to specific pieces of information, the right to port your information, and rights to request deletion. I've heard some complaints about the private right of action. Even though $100 doesn't sound like a lot of money, it could be a lot quickly when you multiply things. I just saw that last month, I think Equifax settled with the state attorney generals over its data breach. And do you know how much money it had to pay? It paid nothing because it promised to do better. So I'm okay with the private right of action as it stands in the California law.
And before we move on, I just want to kind of bottom line it for people. Obviously, this is very possibly going to be amended in the next couple legislative sessions. I know everyone has multiple things they might tweak or change, but I'm going to ask you to make some hard choices. If you have a magic wand, you can change one thing before 2020. What is it? And we can just go down the line.
To be perfectly honest, I would say that we need uniformity, and I wouldn't say it's necessarily with the California bill. I would say that we need to see, increased efforts here on the Hill to create a uniform system for privacy. And I think that
there's got to be one thing though in the California bill, if it wasn't a federal bill, and we'll talk about a federal bill.
Sure. I would say, in terms of the California bill, I think that there is one thing that concerns me is that businesses will now not be allowed to differentiate prices based off of using data. I think that is concerning because of things like frequent flyer mile programs, loyalty programs like your CVS card or anything like that. So if you opt out of having your data being disclosed through sale or through the large broad definition of sale and the bill, not being able to differentiate pricing, I think that's problematic because I think the online ecosystem basically works through data, and then also you're looking at loyalty programs, you're looking at frequent flyer programs. I think that's concerning, and I think even though there is a provision that says you can provide a financial incentive to consumers, I still think we're going to get tangled up in court over what the meaning of value is. And I think that provides uncertainty at this point right now. So I think that's something that I wouldn't necessarily say we need to scrap everything there, but I think at the same time we need to take a better look at that section right there.
And I promise I'll give you the case.
Sure.
I'll give you the chance to make a case for a federal bill.
Sure.
Michelle.
In some ways, I wouldn't change anything because it's really brought the discussion of federal privacy legislation to the forefront. But if given the chance, I think we would want to see some practices addressed that weren't in the bill. So things like deceptive interface design. So a good example would be the Facebook Cambridge Analytica quiz that you may have taken. It was a personality quiz, but really it was about collecting lots of other data. Or the times when you see a tiny, tiny link that says no thanks, but you can barely see it. Those types of interface design can create a lot of deception. We think also cross-device tracking isn't addressed, and that's when your TV and your phone are speaking, and I think that's very unexpected for most people. Device fingerprinting, looking at the idea...
Sorry, what's device fingerprinting for?
Oh, okay. So device fingerprinting, it's just basically a way to identify your device, and so that could be your laptop or your phone or whatever, across multiple platforms and products and services. It's a technical identifier, basically, but it's a practice that follows you wherever you go. So you can not even be using something, you can have shut down your phone, but it's still sort of like these footprints in the sand that allow them to collect and use lots and lots of data about you, whether or not you're engaged with the product or service or not. So very unexpected stuff. And this isn't something that's widespread necessarily, but it does go on. It's a part of the monetization of these platforms, products, and services.
And some of these practices you mentioned, it seems like are practices that may be emerging.
No. These aren't emerging. Mm-hmm. No, these are here. Cross-device tracking has been around for a couple of years now. Again, it's really unexpected, right? And so I think maybe some of what you're expressing is some of the surprise that a lot of people express. But the difference is that more and more people are starting to get more devices in their homes that have the ability to communicate with other devices. So if you've ever had the experience where you turn on something and Netflix is, or some other service, Comcast or whatever, is showing you the kind of content it thinks you want to see, and it's eerily similar to something that you played on your phone or something that you did, this is why that's occurring, right? So they're talking to each other. So I think some of those practices we would have liked to see addressed.
Ryan, magic wand.
Well, I'd probably turn in the magic wand for a flamethrower and just kill the whole thing with fire.
That's not an option. Elon Musk has no sway here.
No, I would actually narrow in on the exact provision that Jordan narrowed in on, which is 1798-125. So this is basically prohibiting any business offering services to consumers from denying consumers who choose to opt out of their data being collected. Can you not hear? Sorry. Usually I'm pretty good at yelling at the mic from away, so. So yeah, this is basically, I don't want to call it a non-discrimination clause. It's a non-price and quality on product differentiation clause. And it's terribly confusing and it's terribly muddled because it basically starts by saying businesses cannot discriminate against consumers because they exercise any of their rights in this bill, including these provisions. And then the next subsection starts with nothing in this subdivision prohibits a business from charging a consumer a different price or rate. And the clause at the end is the important part here, quote, if that difference is reasonably related to the value provided to the consumer by the consumer's data. There's no quantitative information on that at all. Behavioral and experimental economists have been mostly giving up recently, trying to actually quantify the value of individual consumers' data. It's terribly complicated. So frankly, if I had a magic wand, just that whole provision, if I could get rid of one thing, I would just strike the whole thing.
And Ariel, last active magic.
Similar to Michelle, I would like this to address some additional things more directly than it does. Mm-hmm. And for me, I would like, as the GDPR does, for this to address more directly companies' own internal data use and collection and retention practices.
Mm-hmm. And so I think that's a great segue into the question of federal legislation. Right. So one kind of prognostication is that the California bill just becomes a national model, that other states can take it up. But there is, I mean, we've seen all of you are on sort of different angles on this issue, and it seems like there is an appetite among the table here for some sort of federal legislation, not uniformly, but that there's some interest. So because I made a promise, Jordan, why don't you give us the quick case for why there should be federal legislation?
Well, I first of all,
as a response to this.
Yeah, sure. I think there is no more inherently interstate industry than data or communications. Other side, maybe transportation. Regulation of data belongs on the federal level as opposed to having a patchwork of 50 states. I think when we're dealing with, yes, we have California today, kind of enacting kind of de facto standards for the country. I think that is now hindered in a new era, or brought in a new era where the era of self-regulation is over to an extent, and I think we now have to look at a solution on a federal level. I think if California has already started regulating, I think in the near term we'll start seeing states like Massachusetts, Illinois get involved here. And I think that from a consumer perspective and a company perspective, having a clear set of rules for the road is important to ensuring that customers know who to go to if there is a violation of their privacy rights, and also companies know which agencies to actually go to actually get their information on how to comply, and they know who they can deal with, and they can collaborate with the agencies like the FTC to figure out ways to encourage further compliance and also create certainty for the market. And I think in the end, when consumers have confidence and clarity and certainty, I think it really helps everyone in the long run.
And Michelle, you're sort of on the other side of this issue, but you also said one nice thing about this California law is it encourages the potential for federal legislation.
Yeah, one of the more interesting thing about discussing this lately in public is hearing companies use my best lines. It's like unnerving to hear the call for this, but it's great. I mean, because yes, we need a federal baseline privacy law in the United States. It is long overdue. We are the only Western democracy, I used to say us and Turkey, and then Turkey enacted one, that doesn't have one. So granted, it's different in Turkey. But that said, I think it's super late, and we need it. So the question really becomes, how do we do it, right? The devil's really, really in the details and what the approach is. So I can tell you what we think should be done.
I want to get to that.
You just wanted me to say that? Just sort of, we.
No, I didn't want you to, but I want to get to the how. But first, I think, Ryan, you raised your hand saying, no, there should not be a prohibition on selling data. So since I get the sense that you probably do not think that a federal law would be great. Can you walk us through kind of where you're coming from on the idea of a federal legislation?
Sure. Well, so we can start high level and broad, or we could start bottom up and work our way up to broad. I mean, there's a lot of issues.
Let's do broad. Let's start broad.
Right. So let's do broad, and I'll narrow in as much as I can in the time that I have. One of the fundamental presumptions with these calls for federal baseline privacy regulation is that there is a problem to be solved. And I have yet to actually see what exactly the problem is. Now, I understand privacy comes up, people express concerns about it, but people tend to express real concerns about privacy matters that are important to them in very specific contexts, in contexts where specific types of very sensitive information could get out there that they don't want to get out there. And quite frankly, the United States, I think, has the best privacy regulation laws in the world because we are focused on sector by sector by sector. Different types of information used by different sectors in different ways implicate different harms for different people at different times in different contexts. Baseline federal privacy regulation, and this is, I want to go back to my original point here because I really want to emphasize this. Baseline federal privacy regulation doesn't necessarily get you greater privacy protections. It gets you a technological backwater, like they have in Europe. It gets you fewer jobs, fewer innovation, less R&D. What it's not at all clear to me is whether or not you get greater privacy. Because rules like this, complex, convoluted, vague, who has the time, the manpower, and the resources to actually invest in compliance? And it is only compliance. It's not actually protecting consumer privacy. It's complying with the law as written, which is written vaguely. So compliance can mean different things to different people. So what you end up having is the big tech companies that a lot of people are worried about because they're collecting all of this data, you essentially give them entrenched monopoly positions forever because no innovative startups, no new entrants into the market can possibly comply with all the vague statutory requirements of these types of rules. So that would be the broad strokes for me.
So before we get to, so I think, right, we're now sort of understanding there's sort of different levels of there's a spectrum here, right? You have the idea that maybe any sort of new legislation would impede innovation, and then on the other end, we've seen sort of the idea that no, this is really needed, and it's sort of an area where the U.S. has lagged behind.
Can I address one thing that he talked about, which was that harms only occur in context, and that somehow makes them less? I don't think that's true at all. I think I could sit here and list just the names of companies, and you probably know what I'm talking about. Venmo, right? Equifax, Ashley Madison, Grindr. I could go on, and we will, and we'll send this to the Hill. But there are a lot of harms that are also societal harms, collective harms, things like anti-discrimination and ad targeting, right? These things are not, off in the future. They're occurring now. And a lot of platforms don't want this to occur on their platforms either. So the idea that there's somehow no harm just because privacy is contextual, which is true, makes it tricky, doesn't make it impossible or unworthy. We don't have a democracy unless we have privacy. There is no way that it functions without private space. And if you think about sort of broadly too, I think Ariel mentioned the new generation coming up, we have to establish the value of privacy and set the expectation that this is something that is important to our society, right? So one of the ways you do that is you have a baseline. And when you don't have that, you have breaches. You have people's, information getting leaked. There's all kinds of examples. Target, I'm sure you all know the Target pregnancy one. So these aren't, just because they happen to different people in different contexts doesn't make them any less harmful.
Can I just real quick? Because I totally agree. Real quick. No, I totally agree. I absolutely agree with that. My broad point here, and I think what I want people to walk away with, is the recognition that privacy is but one value that we all value, right? There are other issues at play as well. There's economic growth. There is innovation. These things matter for well-being and for earnings for people, right? There are jobs, opportunities. There are many other things that we have to balance privacy with. And the question I think we really need to narrow in on is whether or not broad baseline privacy regulation is the way to go, or if what we have right now has been working pretty well for most people. And I am in the latter camp, but I totally agree. Yes, yeah. Just because privacy does matter in specific contexts for specific people. Yes.
And I said we'd get to how, so I want to get to how. I think one thing that I hope the audience takes away is that this is a really complicated issue. There's a lot of inputs into it and a lot of sort of potential applications. I mean, all these companies you mentioned, I think were instantly recognizable to people, but the circumstances of all of those privacy violations were varied. So how, to the point I cut you off on before, how do you go about writing federal privacy legislation? What does it look like, and how do you make it facile, or not facile, how do you make it sort of malleable enough to fit all of these cases?
Sure. So I can tell you our process. It was to, we've advocated, CDT has advocated for baseline privacy legislation for a very long time, but in the sort of push in the last couple months, we first started with what is a reasonable expectation of privacy for any individual? What should you be allowed to expect in a transaction or in a kind of environment in the digital world? And we came up with a couple values like agency and transparency and accountability as being core to whatever the legislation looked like. From there, we convened different stakeholders to try to build a consensus. It's been incredibly difficult, but it's important to do that, right? Something that people can live with and agree with. Everybody's unhappy, then you've succeeded. So we're talking about industry, academics, and advocates, and then trade associations, UX designers, all kinds of sort of people who are stakeholders in this process, and the public. So the idea is, how do we come to some kind of consensus? And the refrain that we heard from companies over and over again was that we want certainty and flexibility. And the problem with that is there's no legislation that does that, right? There's no legislation that gives you that flexibility unless you take the approach of giving the FTC rulemaking authority on data privacy and data protection. So that's the approach that we've taken. And I think it provides, it's not perfect, it's certainly not perfect, but what we did was say the FTC is an agency that has a lot of expertise in this area. They don't have the authority right now to do anything except ex post, which means after something's already happened. So we provide them with sort of clear limitations. I don't think any baseline privacy bill worth its salt does not have clear limitations on some kinds of uses. Unexpected sharing with third parties. The sharing of location, things that I mentioned before, biometric tracking, location tracking, things that you don't reasonably expect to be occurring. I don't think that a bill should duplicate the GDPR. I think it should draw from it some of the key elements that we think are good, like access, deletion, and portability. And I think it's really important to also kind of inject some conversation about discrimination. And what I mean by that is talking about different values attached to privacy. We're talking about unfairness and what is just in the digital world. So putting transparency around ad targeting. Maybe it's not go after people, and companies who don't have a lot of guidance about how to avoid this, but create a framework that addresses it, that asks the agencies that are charged with enforcing our anti-discrimination laws to look at this space, right? There's some discussions about an ad targeting database, that kind of thing. So I think, and at the bottom of it, there needs to be meaningful enforcement. There needs to be, the agency has to have enough resources, and it has to have the authority to actually have teeth in its consent decrees, for example, not require just assessments, but have audits. There need to be actual fines that make sense. And I think to address some of the concerns about small and mid-sized businesses, that's where you can be reasonable about tiering some of the fines and having thresholds, right? The idea isn't that, I've heard a lot of people say the delis and laundromats of the world, but what about the delis and laundromats of the world? And, they are collecting data too. Right, they're using it too, and in fact may have less concern about the privacy and security of it than they should. So we think it should. So finally, I would just say we think it should cover all sectors, including nonprofit sectors. We are not excluding ourselves from this law.
And news outlets.
Yeah, sure. To the extent that we're not talking about your First Amendment activities, right? But your commerce activities, yeah.
And Ariel, you were nodding throughout a bunch of that. Is there anything you would add in terms of what you'd like to see in a bill, if Congress can get it together?
I mean, we'd love it if Congress could get it together and have a strong privacy bill, and we'd be happy to have a strong standard for America. I mean, I think we think it's really important, whatever we do, to recognize kids and teens and their special vulnerabilities. And if everything is super strong for everyone, then we don't need special rights for kids and teens. But if we're starting to waver on certain rights for adults, then we would want to ensure that kids and teens are the most protected, both in terms of things like user design that Michelle was talking about, and in terms of things like notice and understanding and expectations. I mean, they have different expectations and different comprehension levels than adults do, and our comprehension level as adults isn't super high all the time, so we think we need to particularly watch out for them.
And Jordan, before we head to audience questions, how far would you like to see a federal bill go in preempting state rules? Is there anything that would be left to the states?
Well, I think that there is some discussion to be had about that. And the Chamber is actually leading an effort of industry to develop privacy principles. And I couldn't agree more with Michelle on the need for consensus across the board, amongst, industry groups as well as, citizen groups. So we have developed, a privacy principles working group with industries ranging from health to telecommunications to retailers. Our president and CEO, Tom Donahue, was quoted in Politico, I think about 2 weeks ago, saying that we are developing privacy principles with the hope of seeing some form of federal fix. So we think consensus is important. We think getting input from, outside groups is important. We're working with policymakers right now about what that might look like. In terms of what is preempted, I think that in the long run, the more we have the federal government involved with this data issue, the better than the states creating a patchwork. I think there are important things to talk about, like transparency and providing consent based on sensitivity of data. I think there are still conversations going on, but this is what I like about this conversation here in D.C. is that we have time, and I think there's a willingness now to get something done as opposed to kind of rushing something through in a 4-day period. And I think we can have a good, robust conversation about what privacy looks like. And I think, we've got a year before implementation of the California bill on January 1st, 2020. So I think, this is a kind of the right time for us to be talking about this issue and really making sure we get privacy right on a federal level.
So, been on this beat for a long time. People generally publicly like to be very optimistic, but just to be realists here for a second, who here at this table thinks that Congress will get a federal privacy bill done before January 1st, 2020?
Before January 1st? That's a tough.
You said
2020.
Oh, 2020. Yeah.
Oh,
yeah.
I do then. Sorry. I think you said 2018.
You do.
Well, I'm an optimist. I'm sort of idealistic. I don't know that the bill will look like I would hope in my fevered imagination, but I think it's possible that there will be elements of protection that get put into play. And in fact, the bill that we are writing, we've designed it so that parts of it could be broken out and still stand as protection.
Mm-hmm. So now we've all talked a lot. I'd love to open the floor up to questions, and we'll I will. Yeah, we'll repeat the question so to make sure people are. And so, yeah, if you want to collect their thoughts, we can start over there. And I would just say, I've covered a lot of these panels. The more the questions can be questions rather than comments, the better for everybody involved.
Well, so to start, the definition of personal information is broad enough that it essentially includes, it could theoretically include all information, like everything, just everything, including aggregate information. Yeah, the de-identified information is, yes. So, well, the definition of aggregated is, I actually have to go back to my notes there because I remember making a comment about that somewhere. This is a 10,000 word bill, so I had a lot of notes. Sorry. You might be, you might be right.
Well, and the questions I understood, so how do you deal with that when that's what a lot of companies use? So the question is, what is the harm in the case of aggregate data?
What's the harm to the companies? You're talking about companies being able to innovate and expand and grow. So I'm wondering what the harm is when they can't use these personal, very in-depth pieces of information.
Well, so there's lots of examples. I don't have a lot of examples just off the top of my head, but data is fed into all sorts of other product offerings that companies develop, right? So Google makes most of their money on advertising revenue. That money gets shifted around to go into new moonshot projects that could potentially see autonomous vehicles on the streets. It goes into Google Loon to provide internet access to underserved rural communities. So my point on the personal information definition and also the business definition is that when you start to broaden those definitions in such a way that you scoop up more and more and more things without actually narrowing in on a very particular problem that you're trying to solve with regulation, the floodgates are open for all sorts of who knows what to happen, unintended consequences. By forcing an opt-in requirement, you actually increase the transaction cost of individuals handing over data, which I will not say is the oil of the digital economy because that's a misnomer, but it does help fuel the digital economy. So you're placing an artificial tax where there wasn't one previously in order to address a problem that isn't clearly specified to begin with. Just real quick, my broader concern with the California bill in particular, I mean, I'll talk all day about GDPR, but it's across an ocean for now. My broader concern with the California bill in particular is that provision that I mentioned, 1798-125, which is basically just a free rider provision. So if you opt not to hand over your data, I put quotes around your because that's a complicated conversation that I don't really want to get too deep into because it leads us down the rabbit hole of philosophy. But if you opt not to hand over data to the company, you still get the same services as everyone else. So there's no incentive for anyone not to hand over data, and that's when you start to see a ripple effect in the digital economy that does start to impact jobs and future opportunities and wages, and just hundreds of thousands, upwards of 10 million people are directly or indirectly tied into the digital economy. Those are real people who have lives that they live every day, and it might not seem like that because the internet is so abstract, right? But the things that we do in Washington, the things that they do in Sacramento, have a real world impact on those people and their ability to live day to day.
I saw a question over there, and then we'll. Yep.
So, we're going to work for Marcy Kepler. What are the pros and cons of simply lifting the current protection for misuse of data, and just let the actually prosecuting harm solve problems.
And the question was, I'm just repeating the question for people in the back, what are the pros and cons of lifting just the prohibition on tort litigation against the companies for misusing third-party data? Anyone want to?
So is that basically the why not let the common law deal with it? Yeah, I'll defer.
Jordan, you did. Oh, Michelle, you want to jump on the grenade?
Sure. I think that there are merits to that idea, including the extreme speed with which companies would completely change their approach to all of this and likely put privacy as the number one priority in security. I do think, though, I think that the way that regulation has occurred now represents a market failure. To open up litigation, while it would give individuals the right to bring suit, and I think that that's not necessarily a bad thing, it also creates a situation where companies are spending most of their time fighting lawsuits, spending a lot of money to defend themselves, and it's not clear what those remedies really are, right? It's one of the issues actually in the California bill, I think, is the limited private right of action includes a right to cure with companies. So the companies say there's a data breach, you can go to them and they have a certain amount of time, like 30 days or something, to cure. But how do you do that, right? How do you cure that violation? And similarly, what is the remedy beyond money for that? So I like the idea of the incentive, the sort of push there, but I think the reality may not actually end up protecting people. And those types of suits leave a lot of holes, right? It's really just dependent on who decides they can represent an issue at a certain time, at a certain place, who has the money to bring suit. So I'm not sure that it would cover all of the issues that we care about, including discrimination issues.
And are the courts prepared? Would the courts even be prepared to hear suits on some of these issues? I mean, they're pretty technically complex, and sometimes courts have struggled to wrap their head around some of the stuff.
I think that's a fair point. Yeah, I wouldn't generalize all of the courts like that. There are judges who have really tried to learn a lot about technology. But yeah, I mean, there are plenty of advocates who don't understand a lot of technologies. So I think that's a fair point that and you could end up with some really crazy decisions that, like I said, wouldn't necessarily move things forward. That's why baseline is so appealing. It's sort of everybody has the same rules. Everybody has to abide by the same rules. You're not opening the companies up to a huge amount of liability, but accountability different.
Susan Allen from the Policy Department, USPTO Office of International Affairs, covering IP issues. So I work on GDPR and from California Bar Attorney. So there is a provision in the California law that allows for regulations to be developed in the next year to establish exceptions necessary to comply with state and federal law, including the non-limited to those relating to trade secrets and IP rights within a year. So one question I have, and I'll have a quick comment too, but the question is how much, if at all, do you see the bill shifting as a result of those regulations and provisions? And then one comment I have, and it's just personal thought, I'm representing the PTO, but there's a difference between like the ingredient list, notifying consumers what you're going to be consuming, and then actually giving away the secret sauce to the rest of them. I think that's where, if you're talking about harm, that one thing I do with respect to trade secrets and the influences provision, where there's a little bit more of a balance in the principles of the so if you could give any thoughts about the exception of the regulations.
And just to repeat the question for people in the back and flag if I get it wrong, the question is part of the bill sort of triggers the potential creation of regulations, some around IP. How would those affect the bill as it moves towards enactment? And Ariel, do you want to maybe?
Yeah, sure. So I don't think that the regulations are going to, change the law, but I think they are going to help implement it and clarify things. And as noted here and many times elsewhere, this occurred pretty quickly. So it will be helpful to have the thoughtful regulatory rulemaking process with the Attorney General. And I think some of the things you're raising are things that, when we spoke with industry, they were concerned about. Consumers have a right to request information. What does that mean? What if it's a trade secret? What if it's protected intellectual property? And so having those exceptions being made clear and having the Attorney General have authority to do stuff and to make sure that things that are protected or need to be protected stay protected is something in the bill. And I think this also speaks to the earlier point made about how if you have a baseline federal law, it'd be really helpful to have the FTC go through a rulemaking and help put out specific guidance, and that allows them to both keep the rules up to date as technology is changing faster than Congress could, and we're hopeful that the same thing will happen here in California.
So we have time, I think, for one more question, as long as it's quick. And I see a hand in the back.
About smart toys and how they're seeing that impact kids and teens.
Question was the impact of smart toys on kids and teens.
Sure. Well, so I guess one thing I note about smart toys is they have been the subject of various data breaches and hacks over the last couple of years. And one reason that I said I wished that this security breach language protected more personal information than it does is because a lot of the information that's hacked in this stuff, like personal conversations a parent might have with their kid or messages back and forth, is not protected under the sort of current data breach structure. Common Sense is supporting another bill, an Internet of Things reasonable security bill in California. But that just goes to show, I think smart toys goes to show how there's a lot of really sensitive information being collected about people from bedrooms and from kitchens that might not be being accurately protected in the law right now.
And I think we're pretty much at time, so I think we're going to call it there. But before we go, if you want to go down the line and you want to tell the crowd, plug your Twitter handle, so the website of your organization, where people can find out more about where your group stands or you stand on some of these issues, and they can kind of track the conversation as it continues. So we can start at the end, or...
Yeah, I would say CTEC's website at the U.S. Chamber of Commerce is a good place to look as well. Also, Tech Innovation is the Twitter handle that we have for CTEC at the Chamber. And, you know, I'll be here, too, if you want to reach out to me and chat about privacy. Feel free to let me know.
You can check out our work at cdt.org. We are on the Hill frequently now these days, too, so happy to meet with people and answer questions about the legislation we're drafting. The Privacy and Data Project has a specific tab on our homepage that you can look at, and our Twitter handle is SendDemTech. And if you don't get that right, you end up with like a Chinese newspaper. So make sure it's SendDemTech.
You can find all of the work that I do personally at the Niskanen Center website, niskanencenter.org. But I'm also just going to throw out a plug for my good friends over at the Information Technology and Innovation Foundation, because they do spectacular work on all of these issues. So I really urge you to check them out as well.
So you can find all of Common Sense Media's resources at commonsense.org, and our policy arm is Common Sense Kids Action, which you can get to from there, or the Twitter handle is at CS Kids Action.
And you can sign up for all the Axios newsletters by giving us just one piece of personal information, your email at signup.axios.com. Let's have a round of applause for our panel.